Money, power, people. The business of life and the life of business. What is it that keeps the wheels turning with such speed? What forces exist which govern the economic thrust and parry of commerce? What is fair or unfair? What is a valid transaction and what is not? What are the rules of this complicated game the French call laissez-faire? And who can play? The answers to these and many other questions can be found in the law of contract. But what is it?
Ever since the doctrine of assumpsit was first used in the 16th century to deal with breaches of oral agreement, the law of contract has occupied a relatively prominent role in the common law. In 1570, the Court of Common Pleas began to resile from the previously held view of the courts as expressed in Glaville's Tractus de Legibus et Constitutionibus Angliae. I'll take you through that. Tractus delegibus et conseutidinibus Anglie, which is on your reading list and is as relevant today as when it was first written in the latter part of the 11th century. It is imperative. Imperative, I'll help you there. I-M-P-E-R-A-T-I-V-E. It is imperative that you purchase a copy, although I understand there are only 3 left in the world. It's very good. The law at that time was concerned not a jot, J-O-T, jot.
How boring.
Not a jot.
Let's talk to somebody slightly less tedious.
A contract is an agreement between 2 or more parties to do something or to refrain from doing something which the law will enforce. It's a binding agreement, if you like. But not all agreements are necessarily contracts, and not all are enforceable at law. Well, for a contract to exist, it has to have 6 essential elements. Intention to create legal relations, offer and acceptance, consideration, capacity of parties, legality of object, and reality of consent. Well, to help us understand the first element on the contractual menu, intention to create legal relations, let's look at a not unusual social or domestic situation.
When we got married, he promised me the sun, the moon, and the stars. On the strength of that, I married him. It's been 3 years, and he hasn't delivered even one of the aforementioned heavenly bodies.
Look, I told her a million times. They weren't contractual terms. They were the lyrics to Love Her Come Back. I was singing it to her the night I proposed. It wasn't my intention that they form part of any binding agreement.
Exactly. For a contract to exist, the parties must have intended to enter into legal relations. Now, the law looks at the nature of the agreement to determine whether that intention exists. And if the agreement is social or domestic, the law will presume that there is no intention to enter into legal relations, because most people in social situations do not intend their agreements to be legally binding.
I did.
With business agreements, however, the law will presume that there is an intention to create legal relations, because most people in business do intend their agreements to be legally binding.
What about entrepreneurs?
Of course, millions of people each day enter into business agreements. It is what they do or do not do after that which often leads them to the courts.
So therefore, as I understand it, you're offering to give me 1.
1 or 2, depending.
1 or 2, depending, of your what?
Holding companies.
Holding companies in return for $1 million.
$1 million-ish.
$1 million-ish dollars and a kind of a first option,
Thingy.
a kind of a first option thingy in any of the shareholdings now yet to be formed umbrella companies, which may or may not become available at some time in the future. Is that agreed?
Sort of.
Kinda.
Yeah, nah, yeah.
Good, good. And this $1,000,000-ish is to be paid to whom?
To me. To me, or to my wife.
Madam?
Hello. By when? Yesterday, tomorrow, October, November, by when?
By when?
When is good? When works for me? What year?
Oh, delicious. I got no idea.
Yeah. Right, good. That settled it.
So, from extremely complex corporate takeovers requiring razor-edged business acumen to the simplest day-to-day transaction of which any moron is capable, the law of contract lends its steadying hand. Now then, let's look at the second essential element on our contractual menu.
Offer and acceptance. We asked an expert what is meant by these terms.
G'day, how are you? Offer. It's not a very difficult notion. I'll give you for example. I said to a customer, I say, you want to buy this oxytongue for $300. That's an offer. Nobody accepts that, of course, unless they're a little bit mad, eh? That's offer. I'll give you another example. I'll give you the converse situation. Customer, she come in to me and she say, hey, Gino, I'd like to buy your loins for $300. That's an offer. Pretty tempting too, unless you want to trim it a fat off of the bone, you know what I mean, eh? So, offer, and it's not a very difficult notion to grasp, really, no. There are a couple of rules, though. The first rule is you can't just whisper the offer, huh? You got to communicate the offer to someone who might accept it, huh? What you got to do is communicate it to either one person or to the world at large, like a place advertisement in a paper, eh? So she's not a problem. That's offer. Give you another example. I offer £200 of my prime sirloin estate for 1 cent to the first person who swim at the English Channel, dressed in a gorilla suit, wearing one of Gino's chops on his head. Sorry, mate, that's not really an offer. That one was an invitation to treat.
Well, was Mr. Congenital Lyrino right? Was his statement to the world an offer, or was it an invitation to treat, or an advertising puff, if you like? Well, we took him to court to find out.
Go on, Mr. Clipper.
Certainly, my lord.
We don't call judges my lad in Australia, Mr. Clipper.
Just pandering to the audience's preconceptions, Your Honour.
Very well. Get on with it.
Certainly. Your Honour is most handsome and kind. Your Honour, for an offer to be an offer in the legal sense of the word, there must be a definite promise to be bound, providing that certain specified conditions are met. In the present case, the defendant, Mr. Congenital Lyrino, indicated to the world at large through a megaphone his intention and preparedness to enter into certain obligations, id est, selling £200 of prime sirloin for 1 cent, providing that certain conditions were performed, id est, dressing as the gorilla, tying the chop to the head and swimming the English Channel. Now, these conditions were performed in good faith by my client, Mrs. Renouf. The defendant's submission that the aforementioned statement amounts to nothing more than an invitation to treat or a mere puff or simply an offer to enter into negotiations is, in my respectful submission, and with all due deference to my learned opposition, a heap of crap.
Is that your case, Mr. Clipper?
Yes, it is, Your Honour.
I see. Well, there may be something in what the learned counsel for the plaintiff has said. It is a difficult question of law and one that I shall have to ponder in my chambers for some considerable time. As I recall, in the case of Godzilla...
It's not all that difficult, really. I mean, it's the difference between an offer and an invitation to treat. I mean, if I put an ad in my shop window saying, first folio edition Shakespeare, 12 cents, That's what we lawyers call an invitation to treat. Now, it looks like an offer, and it even smells like an offer. But it's merely an invitation for you to come into my shop and make me an offer.
Why? Because, you see, he hasn't signalled his intention to be legally bound if anyone walks in.
Solid, Jackson, solid. Yes, because what if I had 10 people coming in wanting to buy the same volume?
Well, it'll be mercantile havoc, man.
Right on, baby. Because of the horrendous problems it would cause in the business world, the law says it can't be an offer.
I can dig it. So it's merely an invitation to make an offer.
Now you're cooking, Holmes, your mother.
Right on.
Oh, what a totally heavy dude, man. Oi!
Bailiff, eject that excellent young man and his camera crew before I hold them in contempt of court.
Once a party makes an offer, it is open for the other party to accept it. However, simply deciding to accept the offer does not amount to an acceptance. Silence in the face of an offer will not do. The acceptance must actually be communicated to the party who made the offer. It may be communicated by spoken word, written word, or inferred from certain behavior. Indeed. Having said that, there are some exceptions to this rule of communication to the offeror. This man in green is demonstrating what has come to be known as the postal rule. When negotiations have been conducted through the post, and no particular method of communication has otherwise been prescribed, then the courts will consider acceptance to be complete when posted. This is so even if it never actually reaches the person who made the offer. In other words, if he places his acceptance in the post box before the offer is revoked, then the offer will be deemed accepted.
Well, that was Emil Zatopek of Bolivar with his rendition of the postal rule. And a very fine rendition it was, too. But what did our judge think? I'll give it a 3. Fantastic! And that, of course, means that Emil will be back next week to play for the Iron Lung, the Swiss Holiday Fund Package, and the pink zircon-encrusted sextant. Well, our next contestant is Alfred Quim from Two Worlds, who is going to sing about the definition and function of consideration. Certainly one of my favourite contractual elements, and I hope it's one of yours tonight. Ladies and gentlemen, Mr. Alfred Quim.
Thank you very much, Nick. Love you. Hey, Jack, how's the wine? Thank you. 1, 2, 3, and 4. From a tomtit to a peppercorn, from the day you died to the day you were born, consideration was the norm, I say. Consideration, consideration. C-O-N-S-I-D-E.
Consideration. Oh, the principles of consideration, or what the French might call the raison d'etre, was the subject of much debate during the early part of the 17th century. And whilst that does make for rather dull dinner conversation, it does go to show what an elusive concept consideration was in the early years of the law. Now, consideration is the price paid for what is offered. You've accepted the offer, sure, but you've got to do more than that. You've got to give something back to the person making the offer, and you've got to do it yourself. The consideration can't come from a stranger. Look, for example, say the verbal contract for the sale of this delightful takeaway. Now, Mr. Mopay from down the road offered to make me this tub of tabbouleh for the sum of $6.50. I accepted the offer. I'd be a fool not to. Now, the consideration, the $6.50, that flows from me to Mr. Mopay. Oh, well, it will when I see him again anyway. The consideration doesn't have to be money. You know, it can be a promise to do something or to refrain from doing something. It can be a peppercorn, a tom tit, it could be a goblin's tease made. In fact, anything that the person making the offer is prepared to accept in return. Does that make sense? Look, how's about I show you this example?
Ah, qu'est-ce qui passe ici? Oh, un singe avec du vion sur la tête. Quel diable!
SPS.
Espèce de con! Oh, je dois maman est morte, ou peut-être...
Yes, we have some clear vision now. Good, much better. Hello, Kinder. Excuse me.
That's better. Hello, boys and girls. My name is Tyriano, doll from Hades. Today's story is called Jack and the Beanstalk. That's a good story, isn't it? Once upon a time, a long, long time ago, in a kingdom far, far away, a boy called Jack was taking his mother's cow to market. He was to sell the cow for enough money to cover his mother's hip replacement operation. On the way to the market, he met a man. "Would you like to buy this cow for $2,500 plus anesthetic fees?" offered Jack. "No, thank you," said the man, rejecting Jack's offer. Jack looked very sad, so the man made a counteroffer, offering to buy Jack's cow for some magic beans. Jack thought about this offer long and hard, and after considering it very, very carefully, accepted it. Jack ran home to his mother with the magic beans and told her the good news. She was a little cross and felt that the magic beans weren't adequate consideration in return for the cow. She wanted to take the matter to court, but when Jack explained that ever since the turn of the century, almost anything can amount to consideration, she was happy. Value of the consideration need not necessarily be the same value of what was offered, just so long as it has some value. And they all lived happily ever after. Yeah. So you see, boys and girls, the courts don't want to tell people what they can and can't agree, just so long as the parties are happy with what they are getting, no matter how monumentally stupid it is.
Well, the so-called beanstalk contract was always voidable because, of course, Jack, being a minor, always lacked the necessary legal capacity to enter into the contract in the first place.
Parties must have the legal capacity to enter into a contract. They must be considered by the law to know enough about what they're doing to enter into legal arrangements. There are several categories of persons the law says do not have capacity.
Absolute impeccable taste and case and quality. She's a real beauty, isn't she? Eh? Top of the range, let me tell you. She's got her own reception silo switchboard down there on the left, as you'll see. And, of course, it's got a four-on-the-floor Mag Lemming as well. Like to take a bit of a ride, would you? No, no need for that, I can see. I can see you're a man who knows exactly what he likes, eh? Yes, this baby can get up to 400 revs in the shade, let me tell you. And, of course, all the luxury items on this model are, in course, included, except for the wheels, unfortunately. And at $50,000, my friend, let me tell you that this is a cheaper car at half the cost than you'll not have. There are a few extras, of course, engine included. Now, listen to this. It's cheaper than that. And have we got a deal? Hey, have we? Hey, like to sign here, would you? Thanks very much. You're a treat.
Though the law may vary from state to state, the general legal principle is that minors have limited capacity to enter into contracts. Contracts with minors for necessities like food and clothing will generally be valid. Beneficial contracts of service entered into by minors are also valid. Cash transactions with minors are also valid. However, where payment from a minor is in the form of a cheque, the contract is void. All other contracts with minors are voidable, which means the minor is able to call the contract off if he or she wants.
What?
Other categories of persons lacking capacity are bankrupts, lunatics, and drunkards.
Hey, could you read the link, please, to the next bit? I know you're next, you get an extra $20. Go back. Big smile, big smile, big smile, big smile, big smile. Sell it. That's good, I can read it. Out loud.
Although one may have intention, offer and acceptance, consideration and capacity, one will not have a valid contract unless legality of object is present. In other words, the purpose of the contract must be lawful.
fine all this day. Me sweet beast. Very quick. Look at it! Gold, emeralds, jewelry, inestimable pearl! And now comes time to divvy it up. 4 equal shares for 4 stout fellows.
Well, that's really not quite how we agreed it, is it?
Oh, here he goes again. What?
Well, I thought at our last meeting we agreed that our share would be commensurate with our effort.
Aye.
Well, I don't like to be difficult, but I did shoot 3 people during that last robbery.
So?
Well, you and Doug only shot 2, and Tarquin here only shot 1.
I told you I shot 3.
Look, I'd shot 2 of them already, and you know it.
Ah, but you only wounded him. I finished him off.
Well, I dispute that.
Lads, it doesn't matter.
Well, it hardly matters to you if you stand to gain from my efforts.
Ah, but we all pay for the musket shot, don't we? I mean, technically speaking, we should deduct the cost of the extra shot from your share.
I disagree. Musket shot is a necessary disbursement in the performance of our enterprise. I mean, it's practically an office expense.
Yeah, but expenses incurred while deriving income should be taken from your share, and you can claim a tax deduction.
Well, I would agree if I was a contractor, but you see...
Shut up! Shut up, a lot of yours, or I'll kill you all and I'll have your shares.
Well, legally, our estates would be entitled to them.
Shut up!
Well, if this doesn't amount to a breach of an implied term of our contract, I'd be very surprised.
I said, shut up!
You've almost completely repudiated the terms of our agreement.
Shut up!
I can see my attempts to resolve this matter in an amiable fashion have got us absolutely nowhere. My lawyers will be in touch. Good day.
And so it was that the matter proceeded to court. Unfortunately, things didn't go too well. The law will not allow an agreement for an illegal purpose to be a contract.
Excuse me, it's a virus. So, there you have it. Introduction to contract in 6 easy steps. Intention to enter into legal relations, offer and acceptance, capacity, consideration, and legality of object.
That's only 5.
No, it's 6.
That's 5, isn't it?
No, that is 6.
You've left one out.
No, offer and acceptance are 2.
It's 1 and you know it. You left out reality of consent.
Oh, no, look, no, I'll be able to do it again.
No, it's all right.
No worries. Look, I've got just a bit left.
No, we'll get a professional actor, and I've always said that from the beginning. Cue Tim, reality of consent.
Reality of consent is the last and perhaps the most exciting of all the essential contractual elements. Both parties must, in reality, consent to a contract and understand what the contract is really about. There are several ways in which parties might not really intend to be bound by the terms of a contract.
Yes, very good. Yes, that was great. Checks in the post you hear from Anne.
Mistake. This woman spent $12,000 buying what she thought was a 1955 red MGA. Instead, she ended up with a half-eaten orange. She only realized this after she had driven it home. Misrepresentation. This man was told that the Morris Minor he was buying was brand new and that Sir Donald Campbell had recently used it to break the land speed record. In fact, it was built in 1947 and had no engine. Undue influence. Certain relationships of trust can be abused when influence is used to the disadvantage of the weaker party. And then, of course, there's duress.
And the winner is... misrepresentation!
We'll get this done, Boldy, and then it's oh, Yoli, we've got company, we have. We must go and say hello to them, mustn't we? What a night. Yes? Yes? Oh, I'm sorry, I thought you were a display. Please have a seat, Mr.
Jarvis, Robert Jarvis, you're Mr. Swan, are you?
Yes, well, that depends.
What?
Is there a problem?
Yes, I was one of the unfortunate many hoodwinked into your blatantly misrepresented Swiss holiday fund package.
Oh, what do you mean? It's a barrel of laughs.
What, for you as you deposited money in the bank? Yes, I'm sure it is.
The Swiss holiday fund package is everything it's cracked up to be, and more.
That it's a package, there is little doubt, but it has precious little to do with fun, holidays, or matters Swiss. If I were you, I'd rename it Grueling Hellhole Misery Package if you want to approximate something approaching the truth.
Didn't you enjoy yourself?
If the definition of enjoy has been suddenly broadened to include experiences such as chewing alcohol, then yes, I did.
Well, what are the problems then?
Oh, look, if I might quote from your own thing here.
Certainly.
First-nighters will be treated to a Bavarian feast fit for a king.
Ah, yes.
Yes, well, the Bavarian feast consisted of a packet of crisps and 2 small cakes with little balls on them.
Oh, chef's outdone himself.
So I don't know what kingdom you had in mind. Hutt River Province, perhaps?
Well, that's what kings eat in Bavaria.
Yes.
What about the ambience?
The what?
The ambience, you know, forget the food, the ambience of the evening.
The ambience? Well, that'd be the traditional yodeling as practiced over the centuries.
Ah, yes. Beautiful, wasn't it?
Yes, the renditions were supplied by your wife, who, judging from her accent, Mr. Swan, lives in Thailand.
But
nevertheless, her unaccompanied warblings of old country and western tunes, including Jolene, could even on the most liberal taxonomy of the word beautiful be described as Mahoiby.
Oh, I see what you mean. But what about the snow? Most people go in the Swiss holiday fun package for the snow.
Yes, what snow would that be?
There's snow there.
No, there's not.
Yes, there is snow there.
No, there's not.
Mr. Jarvis, I can assure you there is
snow. If you're
snow.
referring to that little sachet of snow behind the brown ice cubes in the bar fridge, then I think you're being overly technical. Now, I want my money back, and I want it back now.
You make me sick.
What?
You're a big, whinging girl.
Excuse me?
I said you're a big, whinging girl, you tourists all the same. Oh, there's no Bavarian feast. Oh, the yodeling's not competition standard. Oh, there's no snow. Where's your pioneering spirit? Ever thought of going out and hunting for your own food and eating it raw, getting blood all over your face? Ever thought of doing that? Ever thought of teaching yourself how to yodel, impressing your friends and neighbours? Ever thought of doing that? And have you ever thought of hiring a plane and seeing some clouds yourself and making your own snow and skiing about a bit? Ever thought of doing that? Nah, you never did. You've got to have Mr. Swan here to organise everything for you, don't you? Down to the last detail. You know what? Most people go in the Swiss holiday fun package to revel in the majesty of the Alps.
Yes, I was getting to that.
Yeah.
You sent us to Goat Island.
Yes. And there is a very lovely picture of the Alps in the 3rd cubicle of the ablutions block.
I'm not paying $4,500 to sit on a toilet on Goat Island and look at a picture on a calendar. Now, I want my money back, and I want it back now.
Oh, well, why did you say so? Customer's always right at Swan Tours. I'll just get the money out of the safe. She taught me to yodel.
Spain, please. Citura van de Kielet. Prego molto, my. Yes. Yes, I'll be home about 4 o'clock. That's what I said. Right. Bye. No, you hang up first. No, you hang up first. All right. Bye. Stay tuned for more previews. Coming soon, the making of the introduction to contract law. It's a gripping suspense drama as the Borelli family put a contract out on their stool pigeon cousin, Francesco the Armadillo Rogerson. Thrill to their intention to create legal relations. Scream at the offer. Cry at the acceptance. Will the consideration be sufficient? Will the parties have capacity? Is the contract void, voidable, or valid? It's a roller coaster ride from start to finish, and we'll have you guessing if the contract is invalid for illegality of purpose. And what of the reality of consent? All this and less in the making of the introduction to contract law.